Swayam Prabha. Digital India. Educated India.
Students, today we will try to understand a new school of jurisprudence, that is historical school of jurisprudence. Earlier we had tried to understand the meaning of jurisprudence, the first school of jurisprudence, that was the positivist school, analytical school of jurisprudence. And then we moved on to understand the sub branches of the positivist school of jurisprudence. Now is the time that we will start understanding about a new school of jurisprudence, that is historical school of jurisprudence. And in this lecture we will try to understand about the founder of this modern different school of jurisprudence, and then we will also learn about the debate on codification, which was started in the early 19th century by the two famous philosophers of those times in Germany. Those were Thibaut and another was Savigny. And then we will also understand the birth of this new school of jurisprudence, that was called historical school. And then we will also understand the basic tenets of this new school of jurisprudence. Further, we will also try to understand a new word which is called Foxgeist and what is its meaning. Further, we will also try to understand the application of this school in our country Bharat. Further, we will see that who are the other contributors to this school, and finally we will evaluate this school also. Students, let us try to understand about the founder of this school, this new school of jurisprudence, that is historical school of jurisprudence. And that historical school of jurisprudence is founded by the famous philosopher of that time, whose name was Frederick Karl von Savigny. He was born in Frankfurt in Germany in 1779. Just after 10 years of his birth, you might remember that in France there was a great French Revolution. So just before that revolution, he was born in the neighboring country of France, that was Germany, and he was born in a rich family. His father passed away, his mother also passed away. He became an orphan, although he was born in a rich family, but he became an orphan when he was just a teenager. So you might have heard about the French Revolution. At one place there was a revolution, and here also in his family there was a different kind of thing which was happening, and he became an orphan. But he started taking interest in the legal literature, and he read pandects. Pandects, what are pandects? Pandects are about the old code of law that was codified during the time of the great emperor of Rome, whose name was Justinian. So at his orders that great code was codified, and that was called pandects, the complete code. And what you see, that this philosopher started reading these pandects in the personal library of his teacher. His name was wise. So, look at the interest, what he generated. When a person becomes orphan, the person might go here and there and then may waste his time and energy, but this was the person who did not go here and there, but he went in the library of his teacher and he tried to read, because in those times Pandits were not available anywhere. So, but his teacher was having it and he read it and he tried to understand at an early age that what is the law, how the law is made, what is the law on a particular subject. Not only this, he also got interest in historical studies. When he was in different universities of Marburg, Göttingen and universities of Berlin, he also got interest in the study of history. And when he learnt all these things, thereafter he got lot of qualification and he became a professor and also he became a great teacher. In 19th century, the first 3 years, in 1803, he wrote a seminal book and that book was titled Right of Possession. And you know what, that a great philosopher of his times, John Austin, that we had already tried to understand about him, that John Austin declared that this book was a masterly book. So, Right of Possession he wrote in 1803 itself, and thereafter he married a girl whose name was Brentano and she was also an orphan. So, he had met a person of the same kind of family background and thereafter he had a good married life. He had 6 children, but again 2 died, because in those times children could not always remain alive. So, 2 died in infancy, 1 died when she was married. And thereafter melancholic period, and he wrote in those periods 2 seminal books, The History of Roman Law in the Middle Ages and The System of Modern Roman Law. Now, these 3 books that I mentioned you, all those 3 books, they have become classics in the field of legal literature, and whenever you have time you can also read about his books. But in the next slide we will see that out of his whole life what he tried to contribute. He tried to contribute when there was a new era of 19th century, and in the 19th century you see that the German empire that was broken, and what happened, that a different empire that was created. Now, in that times, in 1814, just 100 years before the First World War started in 1914, and 100 years before it, Thibaut, who was another minister of Germany, and this Savigny, they were engaged in a debate about the codification of law in Germany, whether the law should be codified or not. That was the matter of debate. Whether all German states should have a common civil code. This was the kind of debate. You might have also heard about current debate which is going on, that whether we should have the common civil code or not. Likewise, in those times, now it is 2024, and 100 years back, 200 years back in fact, what happened, that such kind of debate was going on in Germany, whether all German states should have a common civil code or not. The minister Thibaut, he was saying that no, codification is essential, and he was arguing in favor of codification, but Savigny opposed codification. He said codification is not required. And what he wanted? He wanted that Roman law should be retained, and not only retained in its full original color, but it must be retained with national perspective. So, this national perspective, he tried to say that the original Roman law is not needed to be incorporated in Germany. And what he said, that look, Napoleon Bonaparte is now defeated and the Holy Roman Empire was dissolved, and thereafter a confederation of 41 formerly independent German states that was created. So, in that era, when Thibaut wrote an essay on the necessity of a general civil law for Germany in 1814, when that essay was published, then Savigny reacted to that essay. Savigny wanted to retort back and say that this is not required now. And Savigny replied through his own way, and he also wrote an essay, and that essay was, because although it was written in German language, Beruf, Unseen and Recht, Uni, Wissenschaft, but the English translation is on the vocation of our age for legislation and jurisprudence. So, in this essay on the vocation, vocation means that the trend, he gave the title of his essay on the vocation of our age, means that was the trend of that age, that was the trend of 19th century. And what was the trend? The trend was in favor of legislation, the trend was in favor of codification. So, what Savigny gave the title of his essay, he said, on the vocation of our age for legislation and jurisprudence. So, that was how he wanted to to answer the debate which was raised by another person of Germany, and his name was Thibaut. So, Thibaut, this is called Thibaut-Savigny debate on codification. So, in this slide what we have tried to understand, that this debate which started in 100 years back from the First World War, that debate was a great debate, that whether codification should be the vocation in Germany or the another thing, some alternative thing was the need in Germany. Let us try to understand that what happened after this. And in the next slide you will see that by this debate, the birth of historical school of jurisprudence, that was possible. A new child was born, a new kind of thought emerged, and that thought was this new school. That new school is called historical school of jurisprudence. Let us try to understand about the essentials of historical school of jurisprudence. What is the first important thing about this historical school? He said that essential prerequisite to the reform of German law was a deep knowledge of its history. He did not say that you can make laws, you can reform the German laws without knowing the German history. He says history, understanding of history, knowledge of history is very important, is a prerequisite, is a sine qua non to reform the German laws. If you think that German laws needs reforms, you should not jump on to say you can do it, but you first start understanding the history of Germany. What he says further, historical research is indispensable means to understand and reform the present. Without knowing the past, you cannot reform the present. Without knowing the past, you cannot say that where are we. Therefore, what he said, that to reform the present times, to reform the present laws, what you need to do, you need to understand the history and you do historical research. And the next step, what he said, that legislators, lawmakers should look before they leap into reforms. What is the meaning of this line? This line became so famous. Legislators should look before they leap. Normally, persons who are very energetic, they want to leap without looking that where that leap will lead them to. And therefore, Savigny gives a kind of cautionary approach, saying that legislators should look before they leap into reforms. So, what is the meaning thereby? What he says, that legislators, where they should look at history of Germany, they should look back, they should look at the culture of Germany, they should look at the society of Germany, and then try to reform the laws. And what he says, that nature of any particular system of law was a reflection of the spirit of the people. Who evolved it? It is not that the particular system of law is a reflection of some other laws. It is a reflection of the spirit of the people who evolved the laws, and therefore that spirit of the people has to be understood. And then you see that he developed his theory. We will try to look at his theory, but later on his pupil Puchta, he termed the spirit of the people, what had been used by Savigny, although Savigny did not give this name, but his disciple, his beloved disciple Puchta, he gave the name to those words. Those words were spirit of the people. Those words were given a new name by Puchta, and that name was Volksgeist. This is a German word, Volksgeist, that is not pronounced as Volksgeist, but it is pronounced as Volksgeist. So, Volksgeist, Volks in Germany, in German language, Volks means people, and Geist mean the law, the spirit of the people. So, Volksgeist is the spirit of the people. You must have heard about the car Volkswagen. It means, it is also a German word, it means wagon of the people, people's wagon. Likewise, Volksgeist means, Volks means people, Geist means spirit, so spirit of the people. So, who gave the term, who gave this new word? His disciples. Sometimes disciples also are great, they are remembered, because you see that how this Puchta made this word famous all over the world, and this word became popular. Now, you will understand historical school when you also understand this word. And Savigny, he was saying that all the law is what? Is the manifestation of this common consciousness, this common spirit of the people, common consciousness of the people, how the people they think, how they think about the law, how do they practice, what is the spirit of the people, that was very important. So, Pukta wanted to look at the society, Pukta wanted to look at the practice of the people. So, in this slide what we have seen that the historical school was born after the debate which was started by the two great scholars and philosophers of early 19th century. Those people were Thibaut on the one side and Savigny on the other side. Further, we will also look at the basic foundations, the basic lessons, the basic teachings of the historical school. What are the basic tenets? And we will try to understand at least around 8, 9 basic tenets of this new school. The first was that law is nothing, law is not commanded by a sovereign, law is not commanded by some people who are political superior, but what he says, law grows with the growth and strengthens with the strength of the people. So, people was at the forefront for Savigny. He said that it is not that the legislators are giving strength to the law, but people gives a strength to the law. And not only that, what he said, law dies away as the nation loses its nationality. So, when the nation is not there, then law will also not be there. Law and nation are connected very, very strongly, and they are like a umbilical cord by which they are joined, and they cannot survive when one is not living. So, what he says, law dies away as the nation loses its nationhood. What is the nation? He says that a nation is meant that a community of people, those community of people who are linked together by some ties, those ties amongst the people may be historical, may be geographical ties, and may be cultural ties. But people, community of people, they are linked with each other, and then they make a nation. A nation is not simply having some residence of some people, but a nation means that people are connected to each other. People are connected to each other on the basis of historicity. People are connected to each other on the basis of cultural ties. People are connected with the same common geography, like a coastal, some people who will be living on the coast of a sea, they will be saying that no, we are persons who love oceans. People who are born in the fields, they will say that no, we are the people who love the fields, the great farms. So, you see that this kind of geographical bonding, people who are born in the mountains, they will have love for the mountains. So, geography and history and cultural ties, all these ties, when they are combined together, they will form a community of people, and that community of people will ultimately make a nation. And law is what? Law is a matter of unconscious growth. It is not a very kind of conscious growth in the initial phases. In the initial phases, it is what? It is a growth which was unconscious. And therefore, any law making should follow the course of historical development. How the historical development, and in that way the law should also follow. If the historical development is following in one direction, then the law should not follow in another direction. Then what will happen? The law will be of no use. And therefore, what he says, that legislation should always conform to the popular consciousness. Means that if historicity of the people that go in one direction, law should not be made in another direction. Legislation should conform to the popular consciousness. What is the popular consciousness about a particular thing? If that is known, then the legislators will make laws and those laws will be effective. And further what he says, law is not of universal application. Law has national character. Law should not be made which someone will claim that it will be applicable in the whole world. Law is having national character. It varies with people, it varies with ages, and therefore law has the national dimension, law has a geographical dimension, law has a cultural dimension. He says natural law lacks such historical understanding. Natural law says that law should be made universal, law should be applicable to the whole universe because it is a natural law. But historical school, which was founded by Savigny, he says that law should not have universal application, and therefore he rejected this natural law approach that we should try to make any laws universal in nature. And what he says, that codification should be preceded by study of laws which is organic, which is progressive, and which is scientific. So, unless you do not study the laws scientifically, unless you do not study the law in an organic way, you cannot codify the laws. And codification was needed. You say if you codification is needed, it meant that you look at the study of law in this way. So, what we try to understand in this slide was that what are the basic tenets of this historical school, how that historical school is connected to the life of the people, how that school is connected to the popular consciousness of the people. That is very, very important to understand. Now, in the next slide, we will try to understand the elaborated meaning of the term Volksgeist. I told you that Volksgeist in German means that the spirit of the people. So, he says what is the spirit? Is the popular conviction, is the people's will. Now, popular conviction is different. He says popular conviction is not the conscious product of the people's will. Conviction can change. Conviction changes in a very rapid pace, but the popular conviction is therefore different than the conscious product of the people's will. He says the popular conviction is not Volksgeist, but the conscious will of the people, that is called Volksgeist. And once you understand the difference between popular conviction and the popular consciousness, which was termed as Volksgeist, then only you will understand further. And then what he says, that earlier we have seen that law develops with the nation and law dies with the nation. Here he says law develops like language. Law, language, custom, government, they do not have separate existence. They derive its authority from the popular consciousness of the people. So, law develops like language. You know that there are several languages in our country? Do you understand that those languages developed in only this country or in some other countries or in all the countries? Law develops like language, means you say that every 5 kilometers there is a change of language. Likewise, laws should be developing like language, custom, people's practice, and the government, is government different from the popular consciousness? He says no, government is not different from the popular consciousness. So, language, custom, law and government, they are all deriving their authority from the popular consciousness of the people. And what he says, that law like language develops with the life of the people. And thereafter, it is very important, because now he becomes little bit technical. What he says, that there are two different stages of development of law. The first stage of development is spontaneous. There is no conscious kind of development. It is spontaneous. According to the principle of internal necessity, law in the early times, which started spontaneously, developed in that way. So, in those times there was no conscious growth of the laws, but the next stage of development comes after the society reaches a certain stage of civilization. The different sides of national activities are divided in different branches, because there is a government and there are so many branches of the government, there are so many national activities which are being done. So, what will happen? It means that such a society has reached a different stage of development, and then these different branches, administrative, executive, judicial branches and many other branches, finance, etc., are then taken up by the jurists, and language by the linguists, scientific development by the scientists. So, what he says, that the different branches, because the society has become technical, the society is not primitive where there are only few things. Now, the society has become technical, it has become complex, and therefore, these complexities will be taken care of by different types of people who are specialists, and therefore, jurists, linguists and scientists, they will be taking care of the different branches of the governance. And then he says that in the hands of these specialists, these subjects become richer in ideas, more complete and technical. Gradually, the things become so technical. You can understand that the age in which we live in, is this a very simple stage of the society? No, we are living in a complex society where there are different technical persons who are involved to deal with different things, technology, finance, economy, and even the cultural things are to be dealt with very, very intricately. So, what we have tried to understand in this slide was what is the meaning of that word fox gist and how it should be understood in the jurisprudential way as was propounded by the champion of historical school, that was Savigny. Now, we will see that how Savigny's theory can be applied to our country, that is Bharat. Do we say that in our constitution, does our constitution gives a national character to the law of our land? The answer is that yes, we have our own constitution. You look at other constitutions, you look at, suppose you take the example of US constitution, very small and very different, but our constitution is based upon the socio-economic and political philosophy of the times. So, our constitution has a national character, and therefore, we try to understand that constitution is not having universal application. It is not the law which will be applied all over the world. So, our constitution, which is a kind of federal constitution, which is having a national application. Then whether our republic is based upon the popular consciousness, the answer is yes. We have a democratic republic. Remember the preamble of our constitution, we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular and democratic republic. Now, what is this? We wanted solemnly to declare our country as a democratic republic, and therefore, when it is a democratic republic, who are the ultimate master? People are the ultimate master. You see that whenever the elections come, whenever the national elections or state elections come, why the politicians, they become so much wary? Because ultimately they have to get the vote from the people, and only then they can survive, they can rule the country, the people, but then ultimate master is who? Ultimate master are the people of the country. Then we have also to see that our constitution, does it also have influence from the outside world? Because you know, Savigny, who was a German, but he favored the application of the Roman law, which was being practiced in Germany for a long time. So, here also in our country, we had to look at other countries, because that was the time when we did not have some features like directive principle of state policy, like parliamentary system. Parliamentary system, we had become used to it, because for the last almost 200 years, the English people were ruling in our country, and they had introduced parliamentary system of governance, and then fundamental rights. But we can't say that fundamental rights, we have only taken it from US, but at that moment of time when the constitution was drafted, our country had its national freedom struggle, and in the freedom struggle, the people they were participating in the freedom struggle, and they said that fundamental rights are very important. And when they were fighting against the colonial system, they were also gathering at many places, and they discussed what is the importance of fundamental rights. And when the constitution was finally drafted and it was adopted by the people, who adopted the constitution? The people of our country adopted the constitution. And when this constitution was adopted, you see that the adoption was containing the fundamental rights. We also have received common law in our country. What is the meaning of common law? Common law means that law which was made by the judiciary and which has not been repudiated now, which has not been repealed by the competent authorities of Bharat. So, those common law which are still being practiced, those are still there in our country. So, like the Roman law which Savigny favored, he said that look at the popular consciousness, whether people wanted to have the old law, whether the same old law would be continuing. And in Germany he said, yes, there was very few flaws that we can remove it, but let us try to understand and then adapt it in the German way. Likewise, here also in our country Bharat, what is the fact that we have received the common law. Receiving of the common law means that we have not repudiated which was given to us, and therefore, this law, if it is there in the people's spirit, the common consciousness of the people, it should not be repudiated. Savigny's theory that the people's consciousness which is practiced by the people, that is the ultimate law for the legislators. He gave primary weightage to the popular consciousness, meant what? The custom, the practices of the people. Now, he subordinated the place of legislation. In that way, he said that which is superior? Custom is superior, not legislation, because legislators should first of all know that the people's practice are much more important. So, what he said, that custom is very important, but if we try to see in our country, there were some practices which were not reasonable, which were not progressive. You might have heard about a custom, sati pratha. There was also the practice of untouchability. These are all against the fundamental rights. These are all against human rights. Child marriage, now these things could not be removed if we could only rely upon the popular practice, popular conviction. But what the legislators can do? Legislators can make amendments if the law is there. If there is no law, legislators can make a new law on it. So, sati pratha was abolished, child marriage has been prohibited, and untouchability has been made a criminal offence, and our constitution guarantees that there will be no untouchability in our country. And also you look at the judicial activism, public interest litigation, how this judiciary, our country's judiciary, they are also making laws, and sometimes it makes laws which are not always based upon the popular consciousness of the people. You remember Sabrimala case? When Sabrimala judgment came, it was kind of debate that whether it conforms to the popular consciousness or the judges will make a different law. But in that case also, you might have known that Sabrimala judgment was in a different way. The court had to also balance the constitutional objectives and the popular consciousness, and then the law which was finally upheld, that was in such a balanced way. So, you should look at some of these judgments when you have time, but now is the time that we should evaluate Savigny's contribution. You see that Roman law was favored by Savigny. Where was Roman law practiced? Roman law was practiced in Germany, and Roman law was also practiced in other parts of Europe except the United Kingdom, and therefore, Roman law was transplanted thousands years back. So, whether that was consistent with the idea of fox gist, sometimes you will wonder that when law has its national character, why was Roman law not repealed in Germany? Why was, but then the answer was, Savigny said that the answer lied in the fact that German law was ingrained in the culture of the German people, and therefore, we should not just remove it. Next is, he said that fox gist would be the sole source of law, but you have seen that the source of law cannot always be based upon custom. It can be, because it can be not always progressive. So, to make the society progressive, what the jurisprudence should have? The jurisprudence should have the avenue for the making of a new society, making of a modern society, making of a progressive society, and therefore, fox gist will not always be the sole source of law. And his idea that custom is always based upon popular consciousness is also not completely true. Popular consciousness and custom, that is not always linked closely in a full way. And you also might have seen that he undermined the power of judges to make the law, because he was saying that even judges should not declare or make any laws when they have not seen that what is the popular consciousness. They do not know what is the popular consciousness. And you can also appreciate that in a small group also people can hold different views. So, a common spirit may not exist. You make a small group, maybe that members of the group, they will have different opinions. So, in that way, what will happen? That you will see that there will be no common consciousness. So, you cannot say that one law cannot be also applied in another country. Look at the example of our penal code and the penal code of Bangladesh, penal code of Sri Lanka. You will find that there are many commonalities, because these places were ruled by the Britishers, and therefore, these are very important, that sometimes it is not always the fact that always national law is essential. Some laws which people practice for a long time, that is also there. Therefore, you can see that German civil code was adopted in a very different country, that is Japan, and the Swiss code was likewise adopted by Turkey, the French code was adopted in Egypt, and the Roman Dutch common law was adopted in Sri Lanka. So, do you find that Sri Lanka decided to reject the Romano Dutch common law? Do you think that Japan decided to repudiate the German civil code? The answer is no. So, when you evaluate the historical school as was propounded by Savigny, you will find that at some places his theory of jurisprudence, that cannot be completely according to the needs of the society of the current times. We have to give importance to the judge made law, we have to give importance to the power of the legislator. So, in this slide we have tried to understand some of the evaluation of the theory. Now, we will also move on to see that some other assessments. Family law, take the example of family law and succession law. You can find national character in the family law. Take the example of Saptapadi in the Hindu Marriage Act. This is not found in other countries. Saptapadi is found in our country only, in the Hindus marriage, if Saptapadi is not performed, then marriage will not be completely final. So, to have a lawful marriage, there has to be Saptapadi, performance of Saptapadi. The recent Supreme Court judgment also, that was to this effect, that the Saptapadi, if it is not performed and if the Saptapadi has not been according to the Hindu Marriage Act, then the registration of marriage, even if it is done, the marriage will not be considered properly legal. So, what I was telling you, that in family laws, succession laws, laws may have national character, but what about criminal law? What about commercial law? What about new laws which are in the field of technology? Technology is not national. Commerce may become transnational. Crimes may be the same, having same element in many other countries. So, they may not have the national character as was said by Savigny. So, in some places he was quite right, but in giving or having understood the other important situations, you can say that he cannot be said that he was totally right. Roman law generally was accepted in Europe, but Roman family law was not accepted. So, Romans have different family laws and Germans have different family laws. So, even when Savigny said that Roman law can be acceptable in Germany, but Roman family law was not acceptable. And further, you might say that sometimes laws are not always made on the basis of the popular consciousness, but laws sometimes are made by fighting. People struggle for their rights, people fight for their rights. It is not that they always okay, just remain calm and silent and practice whatever they want to do, but they have sometimes to go on the streets, they have to sometimes protest, and thereafter the government recognizes the protest. So, what I was telling you, that sometimes laws are developed by the violent struggle also, sometimes by the peaceful struggle also between the conflicting interests within the nation, and not as the result of imperceptible growth. The law relating to trade unions, you remember trade unions law was not made on the basis of the people's practice, and the industry laws, those were the result of the fight for the rights of the laborers, the fight for the right of the working people, because the capitalist, the people who have the industry, they did not want to give fair wages to the labor workmen, and therefore, so sometimes you see that Savigny's theory is quite right, but at some other times you find that his theory is not properly applicable in every aspect or in every different branches of jurisprudence. So, jurisprudence, when we try to understand in a comprehensive way, then we have to see also different other things, but this was a very important school, Savigny's theory, which laid focus upon the practices of the people, which was not prevalent, because you remember his contemporary John Austin, he did not give any kind of weightage to the customary practice. And look at this person, so he was also the contemporary of John Austin, but look at this person, he was saying that no, there has to be a national character. The custom is important, even the legislators, they should not make laws on their own whims and fancies. The legislators have to make laws based upon popular consciousness, and therefore, this was very important contribution of the historical school, and without this, I hope that this the whole lawmaking, that would not have been possible if the legislators would have been given power by the jurists, or in the jurisprudence we would have only said that legislators have all the powers, not by the judges, not even power of the people. Then what will happen? So, we find today we have tried to understand that the historical school of jurisprudence is a very important branch of jurisprudence, which has contributed to give due focus upon the people's practices, to the customary practices of the people, and we also have seen that how in our country the historical school has been partially accepted even by our constitution and by the judiciary. I hope that you might have understood this lecture and the historical school. I hope that if you have any kind of difficulties, then perhaps this lecture will help you in some ways or the other. Thank you so much for your kind attention. Enjoy your day, and thank you.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. Today I want to tell you a little bit about what sociology is. In order to go ahead and study sociology, one of the things you need to develop is a sociological way of thinking. Now, this capacity to think in a sociological manner was termed as the sociological imagination by an American sociologist called C. Wright Mills in 1959. He argued that in order to think in a sociological manner, you should be able to have two different skill sets. The first skill set would require you to have the capacity to think beyond the problems that individuals face. So, if you encounter a problem that some one individual is facing, you should be able to connect it to a broader public problem. Mills gave the example of people in his neighborhood. He says if there is one person who is unemployed in the neighborhood, that seems to be an individual problem, but as a sociologist you're expected to dig around a little. So you come across a couple of other people in your neighborhood who are also unemployed. That indicates to you that rather than being a specific problem, there is a larger public issue at hand. So as a sociologist, you're supposed to look at individual problems and see how they are connected to broader public issues. The second capacity that you're expected to develop as a sociologist is the capacity to link an individual's biography with history. Historical thought may not come to you as the first thing that's connected to sociology, but it plays a pretty important role in the field. So Mills argues that rather than looking at a problem in the here and now, it's important to trace that long historical trajectory that may be connected to this individual problem. Let me give you an example from India, right? Let's say you look at the women in your family. Let's see at what age do they get married. So you may see that your sibling is getting married at the age of 25. Go back one generation. At what age did your mother get married? You may find that she got married a little younger, let's say 21. Go back another generation. At what age did your grandmother get married? You may find that she got married even younger. 18 or possibly even younger than that. So, this capacity to see how the history of a family then influences the age at which your sibling got married, that is the capacity to bridge the biography of a person, or rather by a biography we can also think of the biography of a particular problem with history. What has happened in the past? How is that connected to this individual or this problem in the present? Thank you.